Hello all the viewers, we are here again with a new video. I'm Shashank Mishra with renowned senior advocate of Supreme Court of India, Subodh Markandeji. Today our topic is this major important judgment. In this episode, we are going to discuss the judgment of Divisional Bench of Delhi High Court dated 9/12/2022 in the later patent appeal number 382 of 2019. Bank of Baroda versus Mahesh Gupta, which involved declaration of law on multiple subjects, especially regarding two important doctrines related to law of torts. Kindly give our viewers a sense of fact in the context of which case arose.
Bare and uncontroverted facts are few.
Yes, sir.
Let us see them. On 22nd May 2011, at about 4 p.m., Mahesh Gupta, a modest property dealer, was walking on the path abutting the building where the appellant Bank of Baroda had its branch. On the facade of the building was fixed a huge, that is 36 feet into 4 feet into 4.6 feet, signboard of the bank, which fell on the head of Mahesh Gupta, severely injuring him. The bank did not take any approval of the Municipal Corporation of Delhi before installing the said board. Mahesh was taken to Jayaprakash Narayan Apex Trauma Center of the All India Institute of Medical Sciences, that is popularly called AIMS, where
Yes,
he
sir.
had to undergo brain surgery and remained hospitalized for 38 days. He was discharged on 28th of June 2011. The discharge report described the nature of injury as artifrontal contusion, acute subdural hepatoma, and tracheal stenosis. Even after discharge, he had to be hospitalized for 100 days. Uh, as against the bank, FIR number 144 of 2011 was registered under section 337 of the Indian Penal Code, later on converted to section 338 of Indian Penal Code, resulting in criminal case number 2032958 of 2016, but it resulted in the acquittal of the bank manager. Now it's also on record that Hindustan Times reported on 23rd May 2011 that Delhi had faced the brunt of high velocity winds. So these are the few facts. On these facts, Mahesh Gupta filed writ petition number 494 of 2014, in which judgment dated 8th April 2019 was rendered by a learned single judge of the High Court, which was challenged by the bank before the division bench in what is called latest patent appeal. This is
Yes,
like,
sir.
special appeal in our Allahabad High Court and possibly also in Patna High Court.
Of course, sir.
So this LPA was numbered 382 of 2019. So while the writ petition was kept pending by the single judge, he constituted a medical board for evaluation of the bills submitted by Mahesh Gupta. So in compliance with the order of the High Court, that is division bench, a sum of rupees 19 plus lakhs was deposited with the registry of the High Court. So these are the bare facts.
Sir, what question arose for the considering of the divisional bench?
So the following important questions arose for the consideration of the division bench. Whether writ petition under Article 226 was not an appropriate remedy in the cases involving tort. This was the contention of the bank. Whether before installing such a huge signboard, approval of the Municipal Corporation of Delhi was necessary. Whether the doctrine of strict liability called res ipsa loquitur applied to the present case. whether the bank could raise the defense of vis major, that is called act of God. Does the acquittal of bank manager in criminal case not absolve the bank of its civil liability also?
So please tell us about the finding of the division bench on above questions in seriatim.
On the first question relating to the writ proceedings not being an appropriate remedy, the appellant had relied on the following judgments. SPS Rathod versus State of Haryana, 2005, 10 SCC, page 1, and Tamil Nadu Electricity Board versus Sumati, 2005 SCC, 543. The division bench, after analyzing the first judgment in Rathod's case, distinguished it and held in para 33.4 of the judgment that all that Supreme Court has held in this case was that writ jurisdiction ought to be sparingly used in such cases. It did not say jurisdiction is totally excluded. And that is not to say that it was not to be used at all. Regarding Tamil Nadu Electricity Board case, the division bench held in para 33.5 that Supreme Court in fact held that jurisdiction under Article 226 is not excluded in the cases involving tort,
Yes, sir.
and each case and every case is not to be relegated to suit. Now, on the second question regarding necessity of taking prior permission before installing the signboard by the Bank of Baroda, the division bench held in paras 25 and 26 of the judgment that having regard to the huge size and dimensions of the signboard, it cannot be said that it was not set up on the facade of the building for the purpose other than advertisement. The court reasoned that, if it was merely to indicate that the bank's branch is here, it would have been a smaller board. But this was a huge board, 36 into 4 into 4.6 feet. So
Yes, sir.
Section 143 of the Delhi Municipal Corporation Act required prior permission of the commissioner for setting it up, which was not taken. But the court also came to the conclusion that even otherwise, the bank had a duty to take care about the signboard, that it does not become a hazard for any member of the general public. On the third question about the invocation of doctrine of strict liability, the division bench discussed the point at great length. In para 12 onwards, para 21 onwards,
Yes,
and
sir.
held that it is against the Bank of Baroda, for which it relied upon the following judgments. There is that famous, Raylands versus Fletcher, 1868, 3 House of Lords 330. That's the very genesis of this doctrine of res ipsa loquitur, and of course a number of adventitious cases were also cited. Then another case on which the division bench relied upon was Manindranath Mukherjee versus Mathura Das Chaturbhuj. That is reported in EIR 1946, Calcutta, 171, 175, where a huge banner of 12 feet by 3.5 feet uh, put on a wooden frame fell from the defendant's roof, causing injury to the plaintiff. And the Calcutta High Court held that fundamental rule of principle of strict liability is that liability attaches because of the occupier of the building, occupier of the land, bringing something on the land which, if that object escapes, is likely to cause harm to others. That's the principle. Then the third case which it relied upon is Municipal Corporation of Delhi versus Subhagvanti, which is reported in 1966, 3 SCR 649, where three people had died due to the collapse of a clock on the building belonging to the Municipal Corporation of Delhi. And the last case on which it relied was MCD versus Sushila Devi, 1999 4 SCC 317, where a person riding on the pillion of a scooter had died due to fall of branch of tree maintained by the Municipal Corporation of Delhi. On the fourth question about the defense of vis major or act of God, which was raised by the Bank of Baroda, the division bench held it against the bank. The division bench noticed that the learned single judge had taken note of the judgment of a coordinate bench in Harinder Kaur versus ADJ 2012 131 DRJ 63 that high speed winds are a normal feature in the month of May every year in Delhi, and therefore the bank cannot per se raise the defense of vis major or act of God. It further noticed that the signboard had become, 6 year old, and its bolts and nuts must have become rusted and loosened, which resulted in its fall. And bank was under a duty to periodically maintain and uh, that particular board, which was of such huge dimensions. Although the bank faintly said that an entity called AGPIL had installed it and it was maintaining it, but no material or any document was produced in support of that plea.
Yes, sir.
Therefore, the court held that Bank of Baroda was definitely negligent and not entitled to raise the defense of vis major or act of God. Now, the last question was whether the bank is absolved of civil liability because the bank's manager was acquitted. So, on this point, the division bench noticed in para 31.5 of its judgment that the standard of proof in civil cases is based on the preponderance of probabilities, while in criminal cases, it is based on the principle of beyond reasonable doubt. Hence, the acquittal of the branch manager of the Bank of Baroda cannot result in absolving the bank from its civil liability, especially a liability based on tort. In that connection, the court relied upon the decision of the Supreme Court in Vishnu Dutt Sharma versus Daya Sapra, reported in 2009 13 SCC 729. Resultantly, the division bench dismissed the latest patent appeal of the Bank of Baroda and directed it to release the sum of rupees 18 lakhs 9,244, which was lying in deposit with the registry of the court. So this is a very important case, and the judgment is packed with case law and very well considered judgment, and that justifies why we have uh, discussed this particular uh, judgment. Although naturally Bank of Baroda will uh, challenge it in the Supreme Court,
Yes,
and
sir.
and therefore the finality is still not attained. But nevertheless, it was even education for me to go through this judgment.
Yes, sir. Yes, sir. Of course, it is one of the important judgment for the every law student and the lawyer, and it will have effect on it. And soon the Supreme Court judgment come, we will have a video on that also, sir. Thank you, sir, for your time, and it's all for the day, sir.
Thank you.